the first session which was dealt with by Justice RamKumar regarding the framing of charge and discharge. Now, which is a very, very crucial or rather a vital step as far as a criminal proceeding is concerned. Now, we have Justice RamKumar, after a long spell, limping again towards, normalcy, in the sense that he is convalescing from his back pain. And today's topic, as we know, that assumes much significance or importance. Now, what puzzles me in this particular arena is that, now we know, framing of a charge, it's a very easy thing because the court need not give any reasons. This is what the apex court says. Even in a 3-judge bench headed by Justice Bhanumati in 2020, the Bhavanabai judgment. Now, if you go backwards, say around 4 or 5 decades back, DC Shukla, which is a 4-judge bench, that says that the very purpose of framing charge is to put the accused to notice in precision as to what all are the accusations that he is required to face in that particular criminal trial. Why it is so? Because framing of a charge, that order is subject to section 397. It's a revisable order. And when can an order be revised? When there is a perversity or an illegality. Now, if the court can merely say that there is prima facie material charge frame, whether that could be assailed under 397 is a point which needs much debate. And hopefully today we have one of the best legal luminaries we have the Kerala High Court has ever produced, Justice RamKumar, who is my very favorite judge, and in fact my Dronacharya, whom I have all respects to. And today let us glue our ears to his talk. Thank you so much, sir, and over to you.
Thank you, Mr. Prem, and thank you, Mr. Vikas. I am only confining today's topic to the famous William Slanney's case. Just I propose to analyze William Slanney's case. Now, anybody undertaking a study into the various nuances of the process of framing of charge by a court should know the celebrated case of William Slanney. When I heard this name for the first time, I was under the impression that it is an English case. But it was a pleasant surprise to me to learn that it was a leading Indian case in which there is some interruption. Mr. Vikas? Hello? When I was
Prem talking, it's fine now.
Oh, okay. I was initially under the impression that it is an English case because the name is William Slanney's case. But then it was a pleasant surprise for me to learn that this was a leading Indian case in which the path-breaking verdict was rendered by a constitutional bench of the Supreme Court of India. This decision, this verdict, deals with the intricacies of omission, irregularity, and illegality in the framing of charge by a court. The other day, we have seen the various provisions regarding framing of charge and the court discharging an accused, the specific provisions. We also went through the confusing legal pronouncement by the apex court, saying, giving a lot of definition, unnecessary definition to the wording in the statute. One decision says prima facie case. Another decision says strong prima facie case. Another decision says there should be a sort of there should not be a mini trial. Yet another decision says, in fact, it is a confusion compounded. But then we noted that in a case where the judge wants to discharge an accused, there are enough decisions of the Supreme Court. Likewise, the very same judge wants to frame a charge against the accused in the same case. There are decisions of the Supreme Court. With the result, we have conflicting rulings of the decision of the apex court on this aspect. In a way, it is a boon that we have such a scenario on the legal side, on the judicial side. Anyway, anybody dealing with the question of framing of charge or question of discharge has to study this famous William Slanney's case. This case came up before the Constitution bench upon a reference by two honorable judges who felt that there was a conflict of judicial opinion by two earlier three-judge bench decisions in Nanak Chand versus State of Punjab, AR 1955 Supreme Court 274, and Suraj Pal versus State of UP, AIR 1955 Supreme Court 419. In the same year, two three-judge bench decisions. It appears that there is a conflict of decision. So it was to resolve this so-called conflict of view that the two judges referred the matter to a larger bench, to a constitutional bench. That is how the matter came before the constitutional bench. In William Slanney's case, out of the five judges, three of the judges rendered separate but concurring verdicts, judgments, in which all of them held that absolutely no conflict is there between Nanak Chand and Suraj Pal. Between Nanak Chand and Suraj Pal, there is no conflict at all. All the three judges held. So actually the reference to a larger bench was unnecessary. But all of them unanimously held that there is no reference. Then we will now straight away deal with William Slanney's case. The correct citation of the case is William Slanney versus State of Madhya Pradesh. AIR 1956 Supreme Court 116, corresponding to 1956 Criminal Law Journal 291. Five judges. The five judges were S.R. Das, acting Chief Justice; Vivian Bose, a wonderful judge; B. Jagannath Das, yet another wonderful judge; N. Chandrasekhar Iyer, still another great judge; then Said Jafar Imam, another beautiful judge. All the five, out of these five judges, three judges, namely Vivian Bose, Justice Chandrasekhar Iyer, and Justice Said Jafar Imam, rendered separate but concurring judgments. Now, three separate judgments, out of the three separate judgments, Justice Vivian Bose gave the verdict on his own behalf and on behalf of S.R. Das. That judgment is in AR paragraphs 1 to 73. The judgment by Justice Vivian Bose on behalf of himself and on behalf of Justice S.R. Das. Then by Justice N. Chandrasekhar Iyer on behalf of himself and on behalf of B. Jagannath Das. Then lastly, that is Justice Chandrasekhar Iyer's judgment is from paragraphs 74 to 91. Then lastly, Said Jafar Imam from paragraphs 92 to paragraphs 101. The reason for separate judgment by Justice Imam was that it was he who pronounced the judgment in Nanak Chand versus State of Punjab, 1955 Supreme Court 274, three judges. So he felt that he had an obligation to explain that whether there is any conflict or there is any no conflict between Nanak Chand and Suraj Pal. Now, these paragraph numbers are as given in the AIR citation. Now we come to the details of the occurrence in that case. It is discernible from paragraph 89 of Justice Chandrasekhar Iyer's judgment and also paragraph 72 of Justice Vivian Bose's judgment. Now I have given you a small genealogical chart. One Mrs. Waters, who was examined as prosecution witness 20, PW 20. Mrs. Waters had a son and a daughter. Her son is Donald Smith, who was the deceased in this case. And her daughter is Beryl, who was examined as PW 13. Beryl is the younger sister of Donald Smith. Then we have another brothers, William Slanney and his younger brother, Ronnie Slanney. These are two brothers. Now we will see how are they connected. The occurrence in this case took place on 12/2/1953 at 7 p.m. in the house belonging to Mrs. Waters, PW20, at Jabalpur in Madhya Pradesh. Beryl, that is the daughter of Mrs. Waters, Beryl was examined as PW13. Who was he and the sister of deceased Donald. Beryl was the daughter of Mrs. Waters and sister of deceased Donald Smith. Beryl was residing in the above house where the occurrence took place. The mother and son, Donald Smith, were residing elsewhere, of course, in the same town. The person who was attacked and killed in the occurrence in this case was William Slanney, who was the appellant before the person who was attacked was the Donald Smith. The accused persons in this case were William Slanney and his younger brother Ronnie Slanney. The William Slanney, first accused, was the appellant before the Supreme Court. Even though Beryl was married to a gentleman in England, Beryl, the daughter of Mrs. Waters and the brother of Donald and the sister of Donald Smith, she was married to a gentleman in England. Her husband had turned her out and she had come down to Jabalpur and was living in the house in question, belonging to her mother, Mrs. Waters. The first accused, William, was in love with Beryl. Rather, they started a romantic affair. There's a romance between Beryl and William Slanney. That is why in the genealogical chart, I have shown Beryl and William Slanney, and there's a romantic emblem. But she could not marry him. And Beryl also reciprocated her affection towards him, her love and affection towards William. But then she could not marry him because her husband had refused to give her a divorce. Her husband was in England, refused to give her a divorce. The deceased Donald, the brother of Beryl, did not like the intimacy between his sister and William. Donald used to make attempts to separate Beryl from the first accused, William. On the evening of the date of occurrence, Donald Smith and his mother, Mrs. Waters, went to Beryl's house. There was a quarrel between Donald and William Slanney, who was already in the house. William was asked by Donald to go away from there. Williams left the place. But after some time, he returned a little later with his younger brother, Ronnie Slanney. William Slanney asked Beryl, who was in the first floor of the house, to come down to him. Beryl, his lover, to come down to him, to the ground floor. But she did not come down. Instead, the person who came down was her brother, Donald Smith, who came down to the courtyard. During the quarrel that ensued, William slapped Donald across his face. When Donald shook his fist in the face of William, the latter snatched a hockey stick from his brother Ronnie. William snatched a hockey stick from his brother Ronnie and gave one blow over the head and two blows over his hips. The first blow which was given on the head was a strong blow. It had fractured, the skull of Donald was fractured and he died in the hospital 10 days later. Not immediately. There was no instantaneous death, but he died from the hospital 10 days later. William and his brother were subsequently charge sheeted by the police for an offense punishable under Section 302 read with Section 34, which is one of the vicarious liability sections for vicarious liability. Section 32, Section 302, murder, read with Section 34 of the Indian Penal Code for intentionally or knowingly committing murder of Donald in furtherance of the common intention of the two brothers, William and Ronnie. During the trial of the case, it was proved that the fatal blow was dealt with by William, the first accused, after snatching the hockey stick from the hands of Ronnie. Even though the skull of the deceased was fractured, he had survived for 10 days in the hospital. The postmortem doctor deposed that the head injury sustained by Donald was of a very serious nature and it was likely to result in fatal consequences. The trial judge acquitted Ronnie because there was, according to the trial judge, there was no overt act on the part of the Ronnie to prove that he was acting in furtherance of the common intention of both. But convicted William, that is first accused, for murder and sentenced him to imprisonment for life. This was affirmed by the High Court of Madhya Pradesh. It was agreed by the said conviction and sentence that William approached the Supreme Court. In the Supreme Court, William Slanney, the first accused, argued that since he, along with his brother Ronnie, was charged for the offense of murder punishable under Section 302, read with Section 34 IPC, and when Ronnie, the second accused, was acquitted, the liability of William, that is first accused, for murder ceased to be constructive and it became direct. And therefore, it was impermissible to convict him without a separate and independent charge under Section 302. I suppose you got the point. Both of them were charged under Section 302, read with Section 34. That is, both of them in furtherance of their common intention to murder Donald had committed murder. That was the charge. Therefore, his argument before the Supreme Court was that when his brother Ronnie was acquitted, there's no common intention. Then without a separate charge for murder against A1, William, he could not have been convicted under Section 302 alone, because 302 read with Section 34 was the court charge. He relied on Nana Chand versus State of Punjab, AR 1955 Supreme Court 274, 3 judges. Those 3 judges who decided Nana Chand were S.R. Das, N.H. Bhagavati, and Said Jafar Imam, who is the last judge in this constitution bench, with Justice Imam rendering the judgment. In Nana Chand, it was held that where the charge against the accused was under Section 302, read with Section 149 IPC. 149 is the other provision for vicarious liability, constructive liability. 149 is where 5 or more persons commit an offense in prosecution of the common object of an unlawful assembly. 5 or more persons constituting an unlawful assembly commit an offense in prosecution of the common object of the said assembly, then each one of them will be deemed to have committed that offense, even though only one of them committed, even if one of them alone committed the offense. Under Section 149, the offender need not be a participant even. He need not even actually participate in the occurrence. It is enough that he shared the common object and he was a member of the unlawful assembly. This was relied on by Mr. William. And he said that without a separate charge under Section 302 against him, he could not have been convicted under Section 302 by the courts below, by the Sessions Judge as well as the High Court. And in Nanarjan's case, it was 302 read with 149. What is the main distinction between 304 and 34 and 149? 34 is, though is a constructive liability, it is not a penal offense. It is only called into aid by courts for roping in persons who shared the common intention, who participated in the occurrence in pursuance of the common intention. But 149 itself is a separate penal offense. And it has to be proved that each one of the member of the unlawful assembly, which is not less than 5, they shared the common object, even though all of them did not have been participated in the occurrence. That is the distinction. In Nana Chand's case, the court charge, the accused, Nana Chand was called upon to meet. The allegation was he was vicariously responsible for the act of killing by a member of the unlawful assembly. And the accused in that case contended that he did not elaborately, because even though the actual act of murder was committed by Nanak Chand himself. But then he was charged under Section 302, read with Section 149, on the footing that a member of the unlawful assembly committed the offense, and since he shared the common object of that assembly, he is also vicariously liable. That was the charge against him. He argued that it was not specifically told, he was not specifically told that he was the person who committed the offense. It was only said that he, along with 4 others, committed the offense of murder as a member of an unlawful assembly and sharing the same common object. Therefore, he said that in the absence of a specific charge for murder under Section 302 IPC, he could not have been convicted. And he also argued that when the postmortem doctor and other witnesses were examined, since there was no independent charge of murder against him, he did not elaborately cross-examine those witnesses. And therefore, he suffered a prejudice because of the wrong court charge framed against him. In fact, the 3-judge bench, speaking through Justice Imam, found the merit in his contention, and the bench ultimately remanded the case for retrial after framing an independent charge against him under Section 302. So, mind you, there the charge was 302, read with Section 149 as a member of an unlawful assembly, sharing the same common object. Now, when Nanak Chand was cited before the Supreme Court, it was brought to the notice of the court that another 3-judge bench of the same year, namely Suraj Pal versus State of UP, a year 1955 Supreme Court 419, in which the judges were Justice Vivian Bose, Jagannath Das, and VP Sinha. Though that 3-judge bench had held that on a charge for Section 302 read with Section 149, if the constructive liability under Section 149 had become inapplicable, either due to the fact that there were no five or more persons, there were only less than 5, etc. And if 149 became inapplicable, then failure to frame a separate charge under Section 302 alone was only a curable irregularity, not an illegality as held in Nanak Chand. It is only a curable irregularity which can be cured, and a conviction under Section 302 alone without a separate charge under Section 302 IPC would be permissible unless the accused had suffered a prejudice. That was the argument in this Suraj Pal. There the judgment was rendered by Jagannath Das. And the learned judges accepted that it is only a curable irregularity. But then in that case also, since the charge against him was by virtue of the constructive liability, and he was not told that he was responsible for the murder, he did the act of causing death, then and therefore he could not elaborately cross-examine the doctor and other witnesses. Therefore, he had suffered prejudice. This contention of Suraj Pal was accepted by the Supreme Court, and they accordingly acquitted him. So, in the first case, in both the cases, this contention was accepted, but in the first case, it was held that the case was remanded to the trial court with a direction to frame a separate independent charge under 302. Otherwise, he could not have been convicted under 302 simpliciter. In the second case, this contention was accepted in toto, and since the court had found that, 3 judges had found that he had suffered prejudice, he was acquitted. Suraj Pal was acquitted. Since it was felt that there was a conflict in the two decisions, Nanak Chand and Suraj Pal, the matter was referred to a constitutional bench, as I mentioned earlier. That is how William Slanney's case came up before a constitutional bench of 5 judges referred to above. Now, the findings by the Supreme Court in William Slanney's case, I'll take you to the findings. All the judges unanimously found that the principle that when the charge under Section 149 IPC becomes inapplicable, the accused cannot be convicted for murder in the absence of an independent charge under Section 302 IPC simpliciter cannot be extended to a case involving a charge under section 302 read with section 34 IPC as in William Slanney's case. In Nanak Chand and Suraj Pal, the charge was under section 302 murder read with section 149, murder committed as a member of an unlawful assembly consisting of 5 or more persons. That cannot be compared with a charge under section 302 read with section 34. Taking into consideration the admitted case of the prosecution and the testimony of the eyewitnesses, the judges held that William Slanney, the first accused, had not come there armed with any weapon, thereby ruling out any premeditated plan. The judges further held that his act of hitting on the head of Donald Smith with the hockey stick snatched from the hands of his brother was an instinctual act consequent on the deceased shaking his fist on the face of William Slanney. When the deceased was shaking his fist, William Slanney had to defend himself. So it was an instinctual act of self-preservation. Therefore, it was held that the medical evidence showed that after sustaining the fracture, Donald survived for 10 days. It was not an instantaneous death. 10 days in the hospital, and that the injury inflicted was likely to cause death only, falling under the earlier part of section 299 of the Indian Penal Code. It was also held that the medical evidence showed that after sustaining the fracture, Donald survived for 10 days in the hospital, and the injury was only likely to cause death. Taking into consideration that the overt act of hitting the deceased was done by William Slanney alone, the bench held that it could not be said that failure to frame an independent charge against him under section 302 IPC had caused any prejudice to him, and that no prejudice had in fact been suffered by him. William Slanney was accordingly acquitted of the charge of murder because there was no intentional killing. Causing death by an intentional act was not there. It was virtually an instinctual act of self-preservation. When the deceased waved his fist against him, he was confronted with a very despicable person. Therefore, fearing death or fearing injury, grievous hurt at the hands of this person, he immediately snatched the hockey stick from the hands of his brother and hit him once on the head and twice on his hips. So, but unfortunately for him, that proved fatal. Even there, the victim survived in the hospital for 10 days. So all the judges held that this only amounts to culpable homicide, not amounting to murder, and punishable under Part 2 of Section 304 IPC. And the sentence was reduced to rigorous imprisonment for 5 years from murder. He was sentenced to imprisonment for life. Instead that he was sentenced to, the sentence was altered to, since the conviction was altered from 302 to 304 Part 2, the punishment was also, sentence was also altered from imprisonment for life to rigorous imprisonment for 5 years. These are the facts of the case. Now the legal issues decided in William Slanney's case. This is the learning for every lawyer and every judge. In the independent judgment of Justice Vivian Bose, these are the observations. The Code of Criminal Procedure is a code of procedure, and like all other procedural laws, it is designed to further the ends of justice and not to frustrate them by the introduction of endless technicalities. The object of the code is to ensure that an accused person gets full and fair trial, along with certain well-established and well-understood lines that accord with our notions of natural justice. If he is tried by a competent court, if he is told and clearly understands the nature of the offense for which he is being tried, if the case against him is fully and fairly explained to him, if he is afforded a full and fair opportunity of defending himself, if there has been substantial compliance with the outward forms of the law, then mere mistakes in procedure, mere inconsequential errors and omissions in the trial are not regarded as venal by the court and the trial is not vitiated. So if he had if substantial compliance with the provisions of the trial and he had a fair trial, he was told what he is being tried for and he was informed the case which he had to face, then, and if he was given an opportunity to demolish the prosecution evidence, he was given an opportunity to adduce rebuttal evidence, etc., and he had a fair opportunity of hearing, etc., then merely because there is some violation here or there, that will not vitiate the trial. Beautiful statement of law. Unless the accused is able to show substantial prejudice, in spite of substantial compliance with the procedure, if he is able to show that even though the omissions or irregularities are only minor, he had suffered prejudice or failure of justice, then only the court will lean in his favor. Then the second principle, where there is an express provision in the code, full effect must be given to the plain meaning of the words, as held in Babulal Chowkani versus Emperor, AR 1938, Privy Council 130, that was relied on in paragraph 8. Then third proposition, where there is no express provision in the code, in the cr.pc, when there is ambiguity, the question for consideration would be whether the trial was conducted in substantial compliance with the code. If the trial is conducted substantially in the manner prescribed by the code, and some irregularity occurs in the course of conducting such trial, the irregularity can be cured under section 437 of the old code, corresponding to 465 of the present code. And as was held in Pulukuri Kottaya versus Emperor, AR 1947, Privy Council 67. All of you must be knowing Pulukuri Kottaya is the leading case of the Privy Council on confession. Section 27, recovery. But if the trial was held in a manner substantially different from that prescribed by the code, as was held in N.A. Subramani Iyer versus King Emperor, 28 Indian Appeals 257, Privy Council, the trial is bad and the question of curing any irregularity does not arise. If the trial was held substantially different from the procedure established by the code CRPC, then you can't say that he did not suffer any prejudice, etc. The trial is vitiated. That is paragraph 9 of the Vivian Bose judgment. Then the fourth principle was the question of curing an irregularity can arise only when one or more of the express provisions of the code has been violated. The question in such a case is whether the departure is so violent as to strike at the root of the trial and make it no trial at all, as if or is of a less vital character. It is impossible to lay down any hard and fast rule, but taken by and large, the question usually narrows down to one of prejudice. In any case, the court must be guided by the plain provisions of the code without straining at its language wherever there is an express provision. When there is an express provision, courts are not expected to strain the language and make a departure from the express provision. Then fifth principle, some violations of the code may be so vital as to cut at the root of the jurisdiction or so abhorrent to what one might term natural justice, in which case there may be ex facie prejudice. The accused doesn't have to prove prejudice. Prejudice is writ large or presumed. Prejudice is presumed in the following cases. For example, a refusal to give the accused a hearing. If the accused was not given a hearing, it's a violation of the cardinal principle of natural justice. No person shall be condemned unheard. Audi alterum partem. Second, a refusal to allow him to defend himself. Prosecution has adduced evidence, incriminating evidence has been adduced. He is denied an opportunity to rebut that evidence. He is denied an opportunity to demolish the prosecution evidence by effective cross-examination. It's a vital violation. Third, a refusal to explain to him the nature of the charge, so forth and so forth. Supposing the charge is very cryptic. Charge is a non-speaking charge, and he does not know what the case against him is. That is also a violation of the principles of natural justice, and this also will vitiate the trial. Then sixth, the real question is not whether a matter is expressed positively or is stated in negative terms, but whether disregard of a particular provision amounts to substantial denial of a trial as contemplated by the code and understood by the comprehensive expression natural justice. Then the effect of charging two persons with murder committed in furtherance of common intention falling under section 34, as was done in Slanney's case, William Slanney's case, is that each of the accused is unmistakably told that he participated in the crime. Unlike section 149, section 34, when the charge is framed with the aid of section 34, he is unmistakably told that he participated in the crime pursuant to a meeting of minds, a common intention. Therefore, he cannot say that there is no charge against me that I committed the offense. Every one of them, there is a charge against every one of them that he participated in the crime. Exactly how did he participate is not a matter for the charge to be set out in the circumstances in which the murder was committed, etc. That is not a requirement of the charge. It also means that the accused is informed about the murder and it is immaterial as to who struck the fatal blow. He need not even be told that as to who struck the fatal blow. If the charge is with the aid of section 34 of the Indian Penal Code, then the charge against each of the accused brought into the arena with the aid of section 34 is that he, along with others, committed the act in furtherance of the common intention of all. So all of them participated pursuant to the pre-concert common intention, a meeting of the minds. They met before the occurrence, and it was pursuant to the meeting of minds that each of them participated in the occurrence. Their role need not be the same, but participation in action is a vital ingredient of section 34, unlike section 149. Now, here the distinction between section 34 and 149. Under section 34 IPC, prior consent and element of participation in action should be there. Each of the accused person should be sharing the same intention and should be a participant in the occurrence in some way or the other. But under section 149, the leading feature is only membership of the assembly. It is enough that he was a member of the assembly and each of the members shared the same common object. At the time of committee, participation in the criminal act may or may not be there in section 149. Common object under section 149 does not require prior consent and a common meeting of minds before the attack, unlike in section 34. In section 34, there should be a prior consent and common meeting of minds before the attack. But here that is not necessary. And an unlawful object can develop after the people get there. Even though the object of all the members of the assembly may be common in that their aim may be to commit any of the offences enumerated under section 141 of the Indian Penal Code, the intention of each and every member of the assembly need not necessarily be common, unlike in the case of section 34. The element of participation in action also is not necessary under section 149. This is the vital distinction between section 34 and section 149. Then another proposition. A man may be convicted of an offence although there has been no charge in respect of it, if the evidence before the court is such as to establish a charge that might have been made. If the evidence is such that a charge might have been made, but no charge has been framed. Even though they were not charged with that formality, they were tried on evidence which brings the case under section 237 of the old code corresponding to section 221 clause 2 of the present code. That is the view taken by the Privy Council in Begu versus Emperor, AR 1925, Privy Council 130, and Lachman Singh versus State, AR 1952, Supreme Court 167. Both these rulings were relied on by Justice Vivian Bose. Then we come to the judgment of Chandrasekhar Iyer, concurring judgment. In Nanak, this Lordship held, in Nanak Chand's case, omission to frame a specific charge under section 302 in a case where the charge originally framed was under section 302 read with section 149 IPC, and when section 149 IPC became inapplicable, it was held to be illegal, whereas in Suraj Pal's case, such an omission was held to be only irregular and curable if no prejudice had been caused to the accused. Such a conflict does not arise in a case where two or more accused persons are charged for murder under section 302, right with section 34 IPC, and if one of two persons are charged, and if one of them is acquitted, the other can be convicted of murder even without an independent charge. That is the fundamental distinction between 34 and 149. In 34, there is the participation in action. Therefore, if two persons have been charged under section 302, right with section 34, and if out of the two, one is acquitted, the other can be convicted of murder under section 302 without an independent charge for murder. Unless of course he has no prejudice has been suffered by him. This was one proposition beautifully laid down by Chandrasekhar Iyer. Then, while section 34 does not by itself create an offence, section 149 IPC does create an offence, as held in Karnail Singh versus State of Punjab, AR 1954, Supreme Court 234. There it was, this distinction was brought out. 34 does not create any offence, whereas 149 itself creates an offence. There can be a conviction under section 149, right with the main offence. Of course, punishment can only be, section 149 does not prescribe any punishment, but there can be a conviction under section 149, and the punishment will be that of the main offence, which has been committed as a consequence of the common object of the unlawful assembly. Karnail Singh was, that was a 3-judge bench decision, year 1954, Supreme Court 234, was relied on. In a charge under section 34, there is active participation in the commission of the criminal act. But under section 149, the liability arises by reason of the membership of the unlawful assembly with a common object, and there may not be any active participation at all in the perpetration or commission of the crime. The overlapping arises in those cases where two or more persons commit a murder in furtherance of the common intention, but it is not possible to say which of them was responsible for the fatal injury or whether any one injury by itself was responsible for the death. Two persons are charged under section 302, read with section 34 or 149. But it is not possible to show which among them committed the fatal act or performed the fatal act of killing. Once a member of an unlawful assembly commits a fatal act of killing, all other members of the assembly who share the common object are responsible for murder. But if in a given case, it is not possible to say who among the 5 or who among the 2 in a 34 case was responsible for inflicting the fatal injury, there comes the overlapping. There may be also a case where it is known that out of the assailant, one particular assailant was responsible for the fatal injury and the others are thought to be made liable for the result owing to the common intention to involve. In this case, the appellant has been individually charged with murder and there is proof that his hand caused the injury. And the crux of the question, he was charged for murder, read with section 34. The charge was you as well as your younger brother Ronnie committed murder in prosecute of the common intention of common intention. But then when the charge is with the aid of section 34, participation in action is assumed, is to be presumed. And there is proof about the fact that it was his hand which caused the injury. There was evidence to show that it was he who snatched the hockey stick from the hands of Ronnie and struck at the deceased. So it was his hand. So this is not a case where the actual culprit is cannot be discernible. He can be discerned. It was found out. The charge also, in pursuance of the common intention to commit murder of Ronald, the first accused hit him with a hockey stick, and since both of it was done in prosecute of the common intention of both, you A1 and A2 are charged for murder punishable under section 302. That is section 34 was the court charge. So this was a clear case where, apart from participation in action, there was the clear evidence as well as allegation also that it was his hand of William, which had committed the fatal act of causing the death. The fact that his brother was also thought to be made liable owing to the existence of common intention is neither here nor there, so far as the legality of the conviction is concerned, as there has been no prejudice by way of failure of justice. He cannot plead prejudice. William could not have pleaded prejudice because he cannot say, I was confused because when my brother was acquitted, there was no specific charge. It was I who committed the murder. It was his charge. Oh, and the charge further said that you committed the injury, the fatal injury in prosecution of the common intention, in furtherance of the common intention of both of you. But the court found on the evidence that the Ronnie, the younger brother, had no common intention to commit murder. Therefore, he was acquitted. So his acquittal is of no consequence as far as first accused William is concerned. Then, lack of competency of jurisdiction, absence of a complaint by a proper person or authority specified, want of sanction prescribed as a condition precedent for a prosecution, etc., are defects that strike at the very root of the jurisdiction. For example, the court is totally inherently lacking in jurisdiction to try that case. Supposing it is a POXO case, and the case is sought to be tried before a chief judicial magistrate. He is inherently lacking in jurisdiction to try that POXO case. Special court under the POXO Act alone can try that case. The case of inherent lack of jurisdiction. Likewise, supposing a person can be prosecuted on the strength of a complaint by a designated authority under the statute. And instead of doing that, a person who is not statutorily designated files a complaint, or a police officer files a charge sheet. These are all cases where there is inherent lack of jurisdiction. Even the cognizance is bad. Then, in the case of public servant, as you all know, a public servant can be prosecuted only when there is a sanction for prosecution by the competent authority. Supposing a public servant is prosecuted without a sanction, it is inherent want of jurisdiction. And if that trial is allowed to continue, that trial will be vitiated. Trial will be null and void. That's what the Privy Council held. Trial will be null and void if the public servant is prosecuted without the requisite prosecution sanction by the competent authority. Then where there is complete absence of charge covered by section 535 of the old code, complete absence of charge, 535 of the old code, that is corresponding to section 464 of the present code. It is for the court to determine whether there is any failure of justice. Court has to decide whether there has been, although there is no charge framed, there is total absence of framing of charge. But then court will have to decide under section 464 of the present code whether the absence of charge has caused the prejudice to the accused or failure of justice. Where there is an error or omission in the charge covered by section 537, 465 of the present code, the court is bound to have regard to the fact whether the objection could have been or should have been raised at an early stage of the proceedings. If that objection was one which the accused could have raised when the charge was framed, defect in the charge, he could have, because the charge was framed by the court, charge was read over to the accused, explained to the accused, and his plea was taken. If at no stage, because he is represented by counsel, if at no stage he had pointed out the defect in the charge, then he cannot at the fag end of the trial turn around and say that, see, the charge is defective. It contains such and such defect. No, he cannot say. He should have raised it at the earliest opportunity available. In the generality of cases, omission to frame a charge is per se fatal. In the generality of cases, omission to frame a charge is per se, that is on the face of it, fatal. Then, in the case of a sessions trial, the code requires that there should be a charge and it should be in writing. A deliberate breach of this basic requirement cannot be cured by the assertion that everything was orally explained to the accused and to the assessors of the jurors, and there was no possible or probable prejudice. In a case tried by a court of session, graver offences, where the punishment is very stringent, if there has been no charge framed, the prosecution cannot explain that omission by saying that, of course, charge was not framed, but accused was told orally by the judge that you are charged for murder. No. In graver offences, a failure to frame a charge, that too by in writing, is a incurable illegal. It strikes at the root of the jurisdiction. Where conviction is for totally different offense from the one charged and not covered by sections 236 to 237 of the old code, corresponding to section 221(1) and section 221(2) of the present code. If the charge is for minor offense, then there cannot be a conviction for a major offense. Then like a grievous hurt or rioting or murder, the omission to frame a separate and specific charge in such cases will be an incurable illegality, an incurable irregularity amounting to an illegality. The Constitution bench makes a distinction between irregularity and illegality. If it is only an irregularity, it is curable. But if the irregularity becomes incurable, then they call it an illegality. At one stage, one of the judges says that there is no much difference between irregularity and illegality. Both are against law, contrary to law. Then you go to find out whether to what extent there is a failure of justice. There is to what extent there is a denial of fair trial. That's all. Where the charge is a rolled up one involving direct liability or constructive liability without specifying who is directly liable and who is thought to be made constructively liable, the absence of a charge under one or the other of the various heads of criminal liability for the offense cannot be said to be fatal by itself. And before a conviction for substantive offense without a charge can be set aside, prejudice will have to be proved, will have to be made out. So the charge is in a way vague in the sense that it does not say who among the two persons is responsible for the fatal act. From that alone, you cannot infer prejudice. Prejudice is something will have to be made out. In that Surajpal's case, even though they held that it is, the three-judge bench held that it is irregular. It is irregular, that failure to frame the charge is irregular. Independent charge under 302 without the aid of 149 is irregular. They held that he had suffered prejudice because he was under the impression that he was not the person who had committed the independent act of murder. Therefore, he did not effectively cross-examine the postmortem doctor, etc. To that extent, he was able to show prejudice. That is why the three-judge bench acquitted him. Then we come to the last judgment, third judgment by Said Jafar Imam. This judge gave a separate judgment because he was a party to Nanachand. So he had an obligation to explain whether there is a conflict between Nanachand and Surajpal. The appellant William Slanney was charged with murder and nothing short of it, although it was stated in the charge that the offence was committed by him in furtherance of a common intention. If the evidence failed to prove that the offence committed by him was in furtherance of the common intention, it would nonetheless be his offence. If the prosecution failed to prove that the offence was committed by him in furtherance of the common intention, still going by the charge, it was his offence, namely murder. If his act in law amounted to murder, the law does not the law does not require in such a case that a separate charge for murder should be framed, because the charge of murder was already on record with the aid of section 34. So participation is there. Strictly speaking, there is no substantial conflict between Nanachand's case and Surajpal's case. And the question raised by the reference does not arise in this case. So this was an unnecessary reference to the Constitutional Bench. There was no need for a reference because both Nanachand and Surajpal involved section 149 of the evidence of the Indian Penal Code, not section 34, as in the case of William Slanney. As per the provisions of the cr.pc, a charge must be framed for trial of warrant cases and cases before a court of session and High Court. See, if it is a trial before a court of session, or if it is a warrant case, or if it is a trial before the High Court, a charge should be framed. There should be a written charge. While section 233 of the code, corresponding to section 218 of the present code, insists upon a separate charge for every distinct offence. It permits a single trial on several charges in the cases mentioned in sections 234, 235, 236 and 239 of the old code, corresponding to sections 290, 220, 221.1 and 222.3 and 223 of the present code. We will discuss all these sections in the coming lectures. So there's no problem. It's a mandatory provision, and the force of its direction is not weakened by the fact that another provision of the code permits a conviction of the accused for an offence with which he had not been charged. In such a case, that is, where the code permits a single trial on several charges, no question of illegality or irregularity arises, as the conviction is expressly authorized by the code. Then, the framing of charge in a trial of cases in which a charge is required to be framed is one of the important elements in the mode of a trial. On the charge framed, after it has been explained to the accused, the plea of guilty or not guilty is recorded. If the accused pleads guilty, certain consequences follow. If he pleads not guilty, the trial must proceed according to law. When a charge is not framed, obviously no plea of the accused with reference to it is taken, and the trial has proceeded without a plea. Framing of a charge and the recording of the plea of the accused is a fundamental provision of the code concerning the procedure in a criminal trial, and not merely a ritual. Total absence of a charge from start to finish in a case where the law requires a charge to be framed is a contravention of the provisions of the code as to the mode of trial. Conviction of the accused of an offence in such a case is invalid, and the question of prejudice does not arise. So the learned judge said, if it is a warrant trial, if it is a session trial, if it is a trial before the High Court, there should be a charge, that was a written charge. Failure to frame a charge is not only illegal, is itself prejudice. The accused need not have to prove prejudice or failure of justice. That itself is failure of justice. It will be illegal to convict the accused for the offence under section 302 IPC without a charge for the same in a case where the charge was for section 302 read with section 149 IPC. That is the difference between 34 and 149. The omission to frame a charge under section 302 must be regarded as a deliberate act of the court by way of notice to the accused that he was not being tried for section 302 simpliciter. Because if he is charged only under section 302, read with section 149, and if ultimately it turns out that he was responsible for the fatal act, for inflicting the fatal act, then he cannot be convicted under section 302 without an independent charge under section 302. The section 149 cannot come to the rescue of the prosecution to contend that he can be convicted under section 302. Whereas independent charge under section 302. Unlike in the case of section 34. And the conviction of the accused for the offence under section 302 IPC alone will be invalid in such a case. But I have one fundamental doubt. Of course, any one of you can clear my doubt. I may be wrong. Suppose in a case where the charge is framed against A1 to A6, 6 accused persons for murder, punishable under section 302, read with section 149 IPC, and the charge also says that it was A1 who inflicted the fatal injury on the deceased, then on the court either holding that A2 to A6 were not members of the unlawful assembly, or that the common object shared by A2 to A6 was only for giving a beating to the victim, but never to commit murder. Will it be open to A1 to contend that he cannot be convicted for murder without an independent charge under section 302 IPC? According to me, he cannot argue that there should be an independent charge, because if the charge read along with section 149 specifically says that he was the person who inflicted the fatal injury. That is my view. I don't know whether I am right or wrong. Then ultimately, Justice Imam also agreed that the conviction of William be altered from section 302 to section 304 IPC, part 2 of 304, and sentence imposed on him should be rigorous imprisonment for 5 years. This is the sum and substance of William Slanney versus State of Madhya Pradesh. Yes. Any court or any judge or any advocate, any legal practitioner who practices on the criminal side should be thorough with William Slanney's case. This is the Bible. This is the leading case on framing of charge. In what all situations the charge can be defective. Even if it is defective, whether it is fatal to the prosecution or not. How far it is curable, how far it is not curable. Beautiful judgments by 3 great judges and by a constitutional bench of the Supreme Court way back in 1956 Supreme Court. Yes.
This is by perchance he is my namesake. What is the remedy available to the accused in framing of charge in case evidence of accused was collected during investigation by the IO and not made part of the challan?
Evidence of the accused was?
Were collected during investigation by the IO but not made part of the challan.
It need not be part of the charge.
Challan, sir.
Part of the challan. Yes.
Yeah.
You have to.
Remedy?
His remedy is to prove it at the time of when he is called upon to enter on his defense. There is a stage under the Sessions case under section 233. Under section 233, the accused is called upon to enter on his defense. He will have to suggest to the prosecution witnesses and to the investigating officer particularly that he had deliberately shut out the evidence adduced by him before him. And then when it comes to his evidence, when he is called upon to enter on his defense under section 233 cr.pc, he can adduce that defense and tell the court that all these materials I had produced before the investigating officer, but he had, out of some sinister motive, suppressed these evidence from this court.
So once you were talking of, this is on the YouTube, so, by Shivam Singla, what is the difference between common intention and abatement under IPC?
Common intention and
Abatement.
abatement, we are not dealing with abatement.
Yeah.
While dealing with abatement, I'll give you the distinction. Common intention and common object. We dealt with common intention, common intention under section 34 and common object. In fact, there should be a separate lecture on common intention, common object, abatement, and criminal conspiracy. They are all watertight compartments at the first blush, but then they have their play also in the criminal trial.
It means he has given us a fodder to think over
Yeah,
for a session.
right.
That we can have a session on this. So on the Facebook, they have only appreciated. That is by Shekhar, Prashant, and Manoj. Shekhar says, what a deliberation associated with historical case.
Historic judgment. Every counsel arguing on a discharge or framing of charge will have to have in his mind William Slanney's case.
So thank you, sir. And we all pray that you should get more and more healthier, because we know that we always get a healthy talk and insights from you.
In fact, this is my passion turned addiction. Therefore, I will resurrect from the bed and come to any webinar lecture.
Just like they say that you can be down but not out. So thank you, sir. Thank you, everyone. Thank you. Stay safe, stay blessed. Thank you.